arbitrationagreements.org. Welcome to our exploration of legal terminology, where we dive into the depths of contract language to simplify it for everyone. Today we are discussing the arbitration clause. Now you might be wondering, what is an arbitration clause? Well, let's unravel it. But before we do, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. An arbitration clause is a section of a contract that deals with resolving disputes. Instead of going to court, the parties agree to resolve their disputes through arbitration. It's kind of like choosing a private court instead of a public one, and it can be binding or non-binding. In binding arbitration, the decision made by the arbitrator is final and enforceable in court. Non-binding arbitration, however, allows parties to reject the arbitrator's decision and then proceed to court. Arbitration clauses can be found in various types of contracts: employment agreements, service contracts, even cell phone contracts. But why choose arbitration? There are a few reasons. First, it can be faster and less expensive than traditional litigation. A recent study states that on average, arbitration can be 20 to 60% faster than litigation. That's a substantial time saving. Secondly, arbitration allows for privacy. The process is confidential, so the details of the dispute won't end up in public court records. Lastly, parties can choose their arbitrator, something you can't do with a judge in a court case. So for technical disputes, you can pick an arbitrator with the relevant expertise. Also, decisions in arbitration are final. In a court case, if you don't like the outcome, you can appeal. In binding arbitration, there is generally no avenue for appeal. This scent actually benefits individuals and companies alike. Why? Because the appeal process in court litigation can drag on for years and drain time and money out of parties. So next time you're signing a contract, look out for that arbitration clause. Know what you're agreeing to. It shouldn't be a deal breaker, but understanding its implications can give you peace of mind. And there we have it, the arbitration clause. It's not as intimidating as it sounds, right? Do you need more information about the basics of arbitration clauses? If so, head on over to arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. In fact, our experts can even draft an arbitration clause for your company right now. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Successful companies depend on arbitration to save money. You're paying one service per case instead of experiencing the uncontrolled expenses of a standard lawsuit. That's the key reason why arbitration is so popular. Also, what do you think about the basis of arbitration clauses? Does it seem pretty simple or complicated? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.